This video will review key concepts from the second half of the course, which focuses on trials, civil and criminal. To start, we defined civil liberties and civil rights. Before the government can take your life, liberty, or property, they must provide due process. There are two types of due process, substantive and procedural. Substantive due process requires that laws be fundamentally fair. Some individual liberties are so sacred that irrespective of the process the government is willing to follow, these liberties cannot be taken away. Historically, we considered liberties as economic liberties, such as the freedom to contract, as discussed in Lochner versus New York. Today, we think of liberties in the context of personal liberties, personal autonomy, and the ability to make life choices that are important to a person. This includes the right to purchase contraceptives, as seen in Griswold versus Connecticut, the right to engage in private consensual sexual activity, as seen in Lawrence v. Texas, and the right to same-sex marriage, as seen in Obergefell v. Hodges. Procedural due process requires that an individual gets notice and a hearing before their life, liberty, or property are taken away. We looked at this in the context of the right to counsel, as discussed in Gideon versus Wainwright, as well as the right to a jury and a unanimous jury in Ramos versus Louisiana. When we discussed civil rights, we looked at it from the context of equal protection. Equal protection asks the government to treat similarly situated individuals the same. That doesn't mean the Equal Protection Clause is violated anytime the government treats you differently. In fact, many laws treat people differently, as in the case of different taxes for different income levels, different types of driver's license for different vehicles, different workplace safety requirements for various industries, etc. What matters is whether the government treats you differently because of a constitutionally protected category. These include race, gender, national origin, etc. Anytime the government infringes on a civil right or liberty, the court will apply a balancing test. They will ask, what is the civil right or liberty at stake? 2, is it protected? And 3, what level of scrutiny applies? Remember that there are 3 levels of scrutiny. Strict, which is the most difficult, intermediate, which is difficult, and rational basis, which is the easiest. Due process especially applies to criminal defendants whose life and liberty are at stake. We also discussed trials in the context of civil trials. The Code of Civil Procedure provides a roadmap that plaintiffs and defendants must follow to bring a case to trial. It is strict, and often one misstep can create an obstacle to continuing. We primarily focused our discussion on jurisdiction. Jurisdiction is the power of a court to hear a case. There are 2 types, personal and subject matter jurisdiction. Personal jurisdiction asks whether the court can hear cases against a given party. We can establish personal jurisdiction in many ways. Via consent, that is, parties agree in a contract that a certain court has jurisdiction. Domicile, which is the permanent fixed home of the defendant. Service of process, or contact. For contact, the courts have designed a special 3-part test that asks whether the court can reach a non-resident defendant with connections with the foreign state. The 3-part test requires, number 1, purposeful availment and foreseeability, 2, relatedness, and 3, fairness. Subject matter jurisdiction asks whether the court can hear a particular type of claim. Here our focus is on the subject matter of the claim. Federal courts have limited subject matter jurisdiction and can hear federal questions like patent and copyright infringement, RICO claims, etc. They can hear state claims when there is diversity jurisdiction. Here there are 2 elements. Parties from different states are suing, and their amount in controversy exceeds $75,000. State courts have unlimited subject matter jurisdiction and can hear most federal and state claims. A case starts with a complaint where the plaintiff lists their claims, followed by an answer, the defendant's response to the plaintiff's claims. From there, discovery, defined as fact-finding, begins. Various methods are used ranging from written interrogatories, these are questions that require answers, to depositions, that is oral questioning. If the parties do not settle their case during discovery, it will result in a trial. We end our course review with a look at criminal law and procedure. Remember that criminal law deals with the penal code and the body of law that defines crimes. Every crime requires a showing of actus reus, that is the action, mens rea, the intent, concurrence, the actus and mens rea happen at the same time, and causation, a connection between the defendant's act and the harmful result. Consider possible defenses at each stage, especially those that negate intent, like mistake of fact, diminished capacity, insanity, etc. Criminal procedure, on the other hand, refers to the methods by which the criminal justice system functions. Our focus in class was on constitutional rights. The Fourth Amendment protects against unreasonable searches and seizures. Rooted in a reasonable expectation of privacy against government intrusion, officers need a warrant or an exception to a warrant to continue. There are several exceptions, including consent, automobile search, plain view, and search incident to arrest. The Fifth Amendment right against self-incrimination, that is Miranda rights, applies when there is custody and interrogation. The Sixth Amendment right to counsel applies when a criminal defendant is indigent and starts with custody, this is the Fifth Amendment right to counsel, and continues during all critical stages of the trial. This is the Sixth Amendment right to counsel. A violation of a defendant's Fourth, Fifth, or Sixth Amendment rights results in evidence obtained being excluded from the trial. This is called the exclusionary rule.